Legal aspects of hospital administration. So there are occasions when there is a mismatch between the expectations of the beneficiaries and healthcare providers, which are patients and the hospital. Okay, when there is the mismatch of expectation, that usually leads to grievances. Beneficiaries also have become aware about the quality of service and their rights. Okay, so sometimes the hospital has very scarce resources, and at times it is very difficult to quantify the output and proportionate that the service given to them was of quality. From your perception, the quality will be different. From the beneficiaries' perception, the quality will be different. And now the hospitals are also considered as suppliers of services and patients are seen as customers. So the hospitals system also comes under the Consumer Protection Act. Judiciary also treats hospital as an industry now, and there are more and more number of disputes and more cases and litigations we are seeing. It is on increase. Healthcare providers and health administrators have also to be well versed in, they should also know well about the prevailing judicial system, judgment delivery system, duties and responsibilities of the hospital administration, legal rights of the doctors, of the hospital administrators, etc. So coming to the definitions of the legal aspects, first is law. What is a law? Law is an obligation on the part of society, and obligation means you are supposed to, the society is supposed to act in a certain way. Okay, something the society has to give to the nation. That's an obligation. It is imposed by a competent authority, that is like court or constitution. They are competent authority. Not anyone can make law. Okay, a competent authority can only impose a law, and that is usually a Supreme Court, Constitution of India. Okay, the government. These are the competent authorities who can impose a law. And if there is any non-compliance found or caught, it could lead to punishment either in form of fine, okay, monetary fine, or imprisonment, or in some cases both. Okay, so there are two kinds of law. One is statutory law and judgment law. Statutory law is, remember your Constitution of India. Okay, it's a democracy, it's secular. Okay, so and so constitution, that is statutes. Okay, it applies to everyone. Okay, by default all the Indian citizens uh, can thrive on the Constitution of India. Okay, so the Constitution of India is an example of statutory law. Okay, you should not steal, you should not trespass. Okay, you should respect all religion, all castes, that caste. There should not be any discrimination. Okay, so all these things are statutory law followed by everyone by default. Judgment law is what? These are the laws passed by the Supreme Court. Okay, laws that are passed by the Supreme Court. So, for example, the Nirbhaya case that happened, okay, when the legal age for like to be hanged till death, okay, the legal age was you will not give it to a minor. Okay, if anyone is below 18 years of age, they cannot get the death penalty. Okay, but after the Nirbhaya Supreme Court case was given. Okay, the Supreme Court made this judgment. They pushed the age limit to less than 16 years. Okay, any person who is less than 16 years of age, and if they have committed such heinous crime, they will not be punished. But as soon as you cross over the age of 16, okay, if you as soon as you cross over the age of 16, a person can be punished under this law, under this judgment law, with death penalty. So that was a judgment law. The law changed because of the courts of India. Okay, that's an example of statutory law and judgment law. Coming to ethics, what are ethics? Ethics is the social value. Okay, it's a social value which binds the society together in a uniform opinion. Okay, everyone has to function in some or the other ethics. It's your own consciousness. Okay, you as a person also know what is right and what is wrong. Okay, so it also enables a society also to think in what is right and what is wrong. Collective thought process. Okay, as long as people follow the ethical values, there is no need for law. Okay, but when ethical values deteriorate in a population or in a civilization, that's when laws are enacted, okay, by the law making agencies so that everyone, at least by law, they will follow the ethics. Code of Medical Ethics, earlier it was Medical Council of India, but now it is National Medical Commission. So each applicant at the time of making an application for registration under this National Medical Commission shall be provided with a copy of declaration. All the MBBS students who are passing out, they have to sign this declaration and submit it back. And when they sign this declaration, all this code of medical ethics, they have to read, understand, and then they have to comprehend what these ethics say, and they have to duly sign it and then give it back to the commission. Coming to the duties and responsibilities of the physician in general, character of the physician, people who are MBBS postgraduate or graduate, okay, they have to uphold the dignity and honor of their profession. They have to render service to humanity. Reward or financial gain should be subordinate, should not be a priority. Getting money, making money should not be the priority. Giving service to the humanity should be a first priority. Diligent in caring for the sick, okay, should be modest, sober, patient, prompt in discharging the duties without any anxiety, conducting themselves with propriety within their profession and all actions in their life, maintaining good medical practice, continuously improve your own medical knowledge by attending webinars, seminars, conferences, okay, and also should make available to their patients and colleagues the benefits of their professional attainments, whatever they're learning from the conferences, seminars, and all. It should benefit their colleagues and their patients as well. Should practice the methods of healing founded only on scientific basis. Evidence-based practice should be done, and should not associate professionally with anyone who violates this principle. Membership in medical society also, they should participate in professional meetings. Continuing medical education should be there. At least 30 hours for every 5 years, they should be participating in some or the other conferences or any medical education programs. Maintenance of medical records. Every physician shall maintain the medical records pertaining to their own indoor patients or outdoor patients. At least 3 years of inpatient records has to be saved. Okay, it has to be kept. OPD records, they can be, you can restore it in 6 months or 1 year, depending on the hospital policy. If any request is made for medical records, either by the patients or an authorized attendant or legal authorities, if they're involved, it should be issued within 72 hours. Anyone who is asking their medical record within 72 hours, it has to be issued. And it has to be retrieved back as well. Make sure that whatever medical records you're issuing, it should come back to the hospital. A registered medical practitioner shall maintain the register of the medical service certificates, give full details of the certificates issued. Effort should also be made to computerize the records for quick retrieval. Whatever a physician can do, whatever efforts a physician can take to computerize all the medical records, he or she should participate in that efforts. Display of registration number. Every physician should display the registration number given to them by the State Medical Council or the National Medical Council, National Medical Commission. Even in their prescription certificates, receipts, which they give to the patient, registration number should be there. They can also display the suffix to their name, like doctor, dr dot. Okay, so in the medical record, whatever is a suffix given to them based on their specialty, they can use that. And when they are prescribing medications, always use generic names of drugs, not the brand names. Highest quality assurance in patient care. Every physician should aid in safeguarding the profession against admission to it of those who are deficient in moral character or education. For example, if you are as a doctor, if you are aware that a homeopathic doctor is using the allopathic system of medicine, okay, you are obliged to inform the law. Okay, if you come to know that an Ayurvedic practitioner is practicing allopathic medicine, okay, again you are obliged to inform the law. That is that should not be done. If any of your colleagues are drunk, okay, they are not sober and they are practicing medicine, okay, they're coming to duty high on any substance abuse or drugs, it has to be mentioned to the law. Okay, authorities has to be informed. Exposure of unethical content without fear or favor. Any incompetent or corrupt or dishonest or unethical conduct from any other physician or any members of their own profession, like even from nurses or physiotherapists, if you see any of these incompetent, corrupt, or dishonest actions, immediately it has to be exposed. Payment of professional services. Priority should be given to the interest of the patient. Okay, financial interest of the doctor should not conflict with the medical interest of the patient. The physician should always announce their fees before giving any services, and not after the operation or treatment, or you have to say this is your charges before you give any service or surgery. Okay, what will be the exact cost, you have to tell the patients. It is unethical to enter into a contract of no cure, no payment. Then evasion of legal restriction. Physicians should be cooperative in observing and enforcing the sanitary laws of the nation and all the other acts like Drugs and Cosmetics Act, Pharmacy Act, Medical to MTP Act, TOA Act, Mental Health Act, okay, Water Environmental Protection Act. All these acts you should observe and preserve and obliged to follow all these acts. Biomedical waste management, okay, all these policies. Medical legal case. Well, the attending doctor, after history collection and clinical examination, decides that this situation or this patient comes under the MLC, medical legal case. Okay, investigation is required by the law. Okay, in this case, the treating doctor is the one who decides if this case comes under MLC or not. Okay, so especially the doctors who are working in the emergency department, they have to be very aware of reporting each case under MLC or not, identifying them in the first place, identify it as an MLC case or not. Then consent. Again, in consent, you have it's a voluntary agreement between two parties. Okay, even in medical care, patient with this two party is doctor and patient. They both consent that this treatment can be carried out. Professional secrets. Under the law of medical profession, unlike legal profession, okay, it does not enjoy professional secrets. It comes only to medical ethics. That is, right to privacy of the patient must be preserved unless a disclosure is required by the court order. Okay, no other private details or confidential talks with the patient should be sent out. Privileged communication, communication made by the doctor to an appropriate authority in the public health interest is called privileged communication. Okay, it can come in the following category: as an evidence in the court of law. When the court of law has asked an evidence, you have under privileged communication, you can give only talk discuss with the court of law. If it is a social and the moral duty of the doctor to perform something in the larger public health interest. For example, if you know a patient he is carrying an infectious disease and the patient should be put in quarantine, okay, and the patient, if the patient is not following the quarantine laws, the doctor can inform it, let go of the confidentiality uh, clause and inform about this mispractice from the patient to the appropriate authorities. So that also comes under privileged communication. And when a servant is sent by a master for taking the examination results or taking on the behalf of the master, if the servant can take the examination result, it can be done. Legal duties and responsibilities of the doctor. You have compulsory duties and voluntary duties. So compulsory duties by law, you have to follow it. Okay, usually it is the notification and reporting of specific physiologic disease conditions, infections, etc. Like notification of birth and death, notification of notifiable diseases, occupational health hazards, etc. Okay, uh, all cases of tuberculosis, dengue, malaria, chikungunya, okay, vector-borne diseases, they all come under notifiable diseases. Reporting the cases of poisoning, suspected cause of death like homicide, reporting the cases covered under privileged communication. When there is a call for military services, it is compulsory for the doctors to go for military services. Then voluntary duties, here the physician has the choice to go or to not to go. To treat the patient, it's a physician's choice. Should I continue to treat the patient or refer the patient to somebody else? Obtaining consent of the patient for a medical examination. Okay, you can either do it or you can give this task to some other doctor. Obtaining informed consent also, it's not compulsory for the doctor to do this job. Anyone else in the team can also do the job. Issuing medical certificate, it's not compulsory. You can issue medical certificate only when you fit, it is deemed to certify someone. Fitness certificate, death certificate. To conduct post-mortem examination as per requirement. Inspection of prisons also, it's not a compulsory duty. Cases of accidents and medical emergency. Conduct medico-legal examination. Okay, these all are voluntary duties. Only if they want to do, they can go and do these duties. Then Consumer Protection Act. Right to safety. Whatever services you're as a patient, whatever services you're availing from the hospital, okay, it should be safe for the patient's use. Right to be informed. Inform the patient about the disease condition, what all the treatment options a patient can have. That comes as an example. Okay, as a right to be informed. Right to choose. You cannot choose the treatment for the patient. Patient has to make the choice. Okay. Right to be heard. All the complaints of the patients has to be heard. Grievances. Okay, signs and symptoms. Whatever physical complaints the patient are having, register it. Give time to hear it out. Right to redress if they have any feedback, grievances, it has to be redressed by the hospital. Right to consumer education. Health education given in hospital comes under this consumer education. Teach the patient, tell the patient about their disease condition. They should know how it happened. Okay, what will be the complications about the disease condition, what in whatever language a patient can understand. Okay, you have to educate the patient. Then organization of redressal agencies, three levels we have here. So one is the basic level, Consumer Protection Act. It has a three-tier system. So the first tier is a district forum. Okay, so here there is a president and two members. One member should be a woman. Okay, and it is appointed by the state government. Compensation up to 20 lakhs can be claimed from here. And if you're not happy with this, the district forum's judgment, you can go to state commission. Second tier is state commission. President is available here, two members. Again, one should be a woman. Members are appointed by the state government, and the compensation, if it is exceeding more than 20 lakh rupees, but less than 1 crore rupees. Okay, if that is the compensation claimed, that state commission can give this amount of compensation. And again, if you are not happy with it, you can appeal to the national commission. So national commission, president and four members should be the president, one should be a woman. Appointed members are from the central government, and any compensation that exceeds 1 crore rupees. Okay, and in Supreme Court, only if the matter and further appellate is done in Supreme Court, and it has to be an original jurisdiction. Okay, like you should not be going to other courts and then coming to Supreme Court. It has to be directly given to the Supreme Court. The case has to be directly given to the Supreme Court. Next, we have the law of torts. So the word tort, it is it comes from a Latin word tortus, which means doing anything wrong, any wrongdoing to a person. Okay, it comes under civil case, and a case can be lodged. If you do anything wrong to somebody intentionally, okay, it comes under torts. So intentional torts. So here, no, you know that your actions will cause harm to a person, and still you do that action. Okay, hitting somebody, physically abusing somebody, mentally abusing somebody, sexually abusing somebody. Okay, these all are intentional torts. Then negligence, wrongs that had happened because the defendant had a duty to perform, but the defendant didn't perform the duty. Okay, for example, hand washing. Some very simple example: hand washing before giving care to a patient. If the doctor or nurse is not doing hand washing, it's a negligence. It's a case of negligence, right? And then strict liability torts, and the wrongs that hold the party liable without having to prove negligence or fault. For example, giving wrong blood to wrong patient. Okay, wrong blood group was administered to the patient. You don't require any other proof. Okay, the harm that you have caused is evident enough that you have done some negligence. Okay, so these are the different torts, law of torts. So that's all about legal aspects.